Of absence. CEO, do we have any applications?
No, Mayor Cole.
Okay, none coming forward. Okay, receiving petitions, deputations and presentations. This evening we have none. Confirmation of minutes. The minutes are the ordinary meeting of the 2nd of April 2019. Could I please have a mover and seconder to adopt the minutes? Move Councillor Fotakis, seconded Councillor Loden. All those in favour? Thank you. I declare that carried. The next item is announcements by the presiding member. I have a few very brief announcements to make this evening. Just to note that on Thursday the 25th of April we had a very successful Anzac Day service and march at Axford Park. It is really lovely to see this service continue to grow, the support from our community year upon year. I think it just seems to get bigger, and it's wonderful to see so many children play their part. This year we had some really touching poems read by local primary school students, and it's really lovely to see the young generation engage and feel really confident in that situation. So that was a very nice experience for all involved. Also, just to mention that on Monday our 40-kilometre trial officially commenced in our southern residential streets of Vincent, so that is now happening. It's live. The 40-kilometre signs are up, so we're looking forward to studying that in a 2-year trial. Also, just to mention that on tonight's agenda we do have our second Reconciliation Action Plan, which is our Innovate RAP, with a strong focus on employment, procurement and grants opportunities for Aboriginal and Torres Strait Islander peoples. It is a significant step forward for us as we move into really pragmatic and outcomes-based approach to making sure that we close the gap when it comes to outcomes for Aboriginal people. And we started this by engaging 2 trainees that are from our local high school at Arranmore Senior College. It did garner some attention through one of the actions about street names and co-naming, and we think it's a great thing to introduce Noongar language into our community and for people to have a few words that they become familiar with. It's all part of learning about culture. Also, just to note that this Sunday the Mount Hawthorn Streets and Lanes Festival is back, bigger than ever before. It's always a fantastic community spirit out on the streets in Mount Hawthorn. The local people really get behind it, rain or hail or shine, but it looks like really great weather, so really looking forward to that, and hope to see lots of people down there. Okay, now move to the CEO for item 8, declarations of interest.
Thank you. Through you, Mayor Cole, I've received 3 declarations of interest. The first is from Councillor Castle in relation to item 9.7. The extent of the interest being that Councillor Castle owns a property on Buxton Street adjacent to the areas proposed to be consulted on the character retention demonstration project. Similarly, a second declaration of interest from Councillor Toppelberg in relation to item 9.7. The extent of the interest being that the councillor's primary residence is located within the area that is the subject of proposed amendment 2 to the local planning scheme. And the third declaration is from Councillor Fotakis, a declaration affecting impartiality in relation to item 9.5. Councillor Fotakis notes that she has an association with Anita Persudani, who is the landowner of the subject property. The nature of the association is that Councillor Fotakis was an employee of Realmark Proprietary Limited in 2016, of which Anita Perkudani is a director. Mrs Perkudani also displayed one of the council's election campaign posters in the front window of her company's offices on Newcastle Street as part of the 2017 council elections. Thank you.
Thank you, CEO. We will now go around and ask council members if there are any other matters items they wish to bring forward for debate. Councillor Hallett, no. Councillor Castle, Councillor Murphy, Councillor Loden. So you have an amendment on the table.
Yes, 10.2 and 12.1, please.
Thank you. Councillor Fotakis. Nothing further. Councillor Toppelberg.
Item 9.5, thank you.
Councillor Gonchevsky. Okay, I'm just going to check. I did have one. No, that's been, was it 10 point, did someone say 10.2 or 10.1? 10.2, yep, okay. I'd just like to bring forward, oh no, 9.7's already been brought forward. Okay, we're covered. All right, thank you.
Through you, Mayor Cole, I'll read out the list of items which were not subject of a presentation from the public gallery or were not pulled out, which the list I have, including item 9.3, item 9.4, item 10.1, item 11.1, item 11.2, 11.3, 11.4, 11.5, and 13.1.
Thank you, CEO. Could I please have a mover and seconder for the en bloc items? Moved Councillor Castle, seconded Councillor Hallett. All those in favour? I declare the en bloc items carried. Okay, so the way that we proceed through the agenda is we first go to the items that have been raised by members in the public gallery in the order that they have been raised. So that means that we'll be dealing with items 9.1, 9.2 and 9.6 first. So item 9.1 is number 128A, Grosvenor Road, Mount Lawley, proposed single house. Can I please have a mover and seconder for this item? Moved Councillor Toppelberg, seconded Councillor Gonchevsky.
Thank you, Mayor Cole. Just a couple of brief comments. The neighbour at 128 mentioned before about issue. So just to clarify, that the item hasn't been approved. There's a recommendation for approval, but this is the process that it goes through, where it goes to a council briefing, opportunity for elected members and for the public to ask questions or to have matters addressed. In this circumstance, that gave rise to a change to the development, which is not necessarily usual at this stage, but the change in species of the tree was a direct result of that, and the decision itself comes this evening. So this gives us the opportunity to have the information present and to be able to debate it, and not irregularly the decision that's made isn't necessarily in line with what the officer recommendation is. I understand the concerns that have been raised, and I do agree that if for nothing else other than the interest of neighbourly relations, it's probably a good idea to knock on the door of somebody, particularly on a subdivided block, to say, hey, this is what we're looking at doing. In terms of the development itself, it's a small lot. They've gone to the expense and trouble of engaging an architect rather than just looking to a building designer or picking an existing house plan. I think the result of that is something that is appropriate for the area. The southern setback, that 100 mils, is, whilst it doesn't meet the deem to comply, I don't think it has a measurable impact, amenity impact for the southern neighbour. Clearly there will be some discussion about how that southern wall is to be constructed, but hopefully that will evolve long before they break dirt. I'm happy to support the officer recommendation, and I think this is actually what we look for in urban infill, is when people are subdividing small lots, especially where they front the dogleg of a right-of-way, so they're effectively sitting on two lanes, which creates an unusual frontage for the new property. To engage an architect that understands and thinks about the site and its context, I think it's a good result for the neighbourhood and for the occupants and the neighbours.
Well, thank you. Just in relation to how this item was consulted on, I do recall at the AGM that a motion was put forward requesting that when planning matters were consulted on, that the adjoining neighbours or those within the consultation area, it was set out what the design principles were, as well as the deemed to comply criteria, rather than having a sort of the deemed to comply criteria as just having the heading of required. And I'm just wondering if the Director of Development Services could confirm or otherwise if that has been implemented in consultations.
Yes, through you, Mayor Cole. Yes, that has been implemented. We're currently reviewing it again in line with the consultation policy. But yes, that change, it did revert back to what it had been historically pretty shortly after that AGM meeting.
And I guess the other question was just in terms of the request around some further clarification as to how will the residents access the wall. My understanding is that this will need to be through negotiation and agreement between the neighbouring parties, and that's what will need to happen before that access can be provided. Is that correct?
Yes, through your Mayor Call, that's correct. If the in order to construct the wall, if they need to access the adjoining property, they'll need approval from that adjoining property to do that. There are mechanisms through the Building Act that will allow the applicant to gain access if negotiations break down and there's an unreasonable restriction to access the wall in order just to construct. But they're very rarely used, and in all instances I can recall, the neighbours have come to an arrangement in order just to access the wall, to construct it, finish it to the standard that the neighbour is comfortable with.
Thank you for clarifying those two things. Yes, I'm supportive of this application. I understand that there is a 30 centimetre variation from the deemed to comply at ground floor and 10 centimetre from upper 4-bedroom. I agree with Councillor Toppelberg in terms of the overarching impact from an amenity perspective, and agree that we want to see high quality infill development across the city. I think that this looks as though it could go some way to achieving that. And I sincerely hope that the neighbours are able to connect and discuss the access to the wall, and that they enjoy a, neighbourly relationship going forwards from this point.
Thank you, Councillor Gonchevsky. Any further comments, councillors? Look, I'll just add to say thank you to the applicant for taking on board the neighbours' concern about the tree species and the blocking of solar access while the plans as they were with that tree in place were deemed to comply. There was a concession made there to help the neighbour have more access to light, and I think that's a good outcome. Other than that, I do agree with the comments already put forward. So I'll put the item unless there's any further comments. Okay, I'll put it. All those in favour? I declare the item carried. That brings us to item 9.2, which is number 3, Elmer Road, Mount Lawley, group dwelling. Can I have a mover? Councillor Gonchevsky, and seconder, Councillor Hallett.
Thank you, Mayor. Just a question to the Director of Development Services, if the replacement page was able to be circulated to the gallery, the members of the gallery at this point.
Yes, through you, Mayor Cole. The Manager of Governance has just advised me that it's on the website now, so council members will be able to view that. I can run through the changes if that helps.
That would be lovely.
Yes, Director, can you please run through the changes that you emailed to council members dealing with both the privacy issues and also if you could go to the issue of the right-of-way widening?
Certainly. In relation to the privacy, on review of each of the matters that the applicant and the owners raised last week, and between last week and this week in the submission they've provided, administration's reviewed the screening again. So in relation to the balcony and that small 700mm piece of screening that's proposed, administration maintains the recommendation that that screening should be provided. It does allow for direct or oblique. It is an oblique piece of overlooking, but it is still overlooking into that one private outdoor living area of that northern property. In relation to the kitchen window, the applicant provided a cross-section today, which we thank him for, showing the outdoor living area in the kitchen and the potential overlooking from that window in the kitchen, that small window in the kitchen, which was under condition 6.3 required to be screened. If someone stands 600mm back from that window, they will have no view whatsoever into that outdoor living area, and so it's recommended that that condition be removed, that screening condition be removed, and just simply replaced with a requirement for for cabinetry to be provided to 600 mils deep along under that window. In relation to the roof terrace, the current condition requires both the planters that are shown in the plans on the roof as well as vegetation screening. There's no need for that vegetation to be provided. The planters themselves will ensure that there's no overlooking into that property's backyard to the west. So that second part of that condition has also been deleted, so it's no longer recommended. It's just simply that the planters be fixed and put in place. And then in relation to the right-of-way, the application proposes an additional dwelling with sole vehicle access from the eastern right-of-way, as well as pedestrian access onto the eastern right-of-way. The development will rely on and add to the use of that narrow right-of-way and the city's recommended widening consistent with the planning bulletin and the built form policy. The land won't be required to be given up unless or until subdivision occurs, and I understand that there's an amendment there that would allow the continued use of that land, the continued use of the land until or if that site is subdivided. So the fence could stay where it's currently proposed, the landscaping could stay where it's currently proposed, unless a subdivision is proposed.
Thank you. May I just ask, in relation to the updated condition 6.4, it talks about fixed planter boxes. Having a look at the elevations provided, there seemed to be a number of different planters. It didn't specifically seem to indicate that they were fixed in place. What, on a technical level, what does fixed mean? Does that mean inbuilt, or that a planter could be put in situ and fixed to the surrounding wall somehow, and that would satisfy the condition?
Yes, through you, Mayor Cole, fixing it to the wall would satisfy that condition. It's just to ensure that they're permanently in place and they're not easily movable.
Okay. Look, I'm supportive of this application. I am appreciative of, after the issues were raised at the presentation and deputation at the briefing last week, I'm appreciative that the city has, rethought some of the conditions in relation to the kitchen window and the roof terrace. And I guess I will just move can I move the amendment on the buff?
Seconder for the amendment, Councillor Hallett is seconding.
Yeah. Okay, so look, I accept that we're dealing with a grouped dwelling. I can appreciate that it is unlikely that this dwelling is likely to be, that there will, from what has been advised, it is unlikely this dwelling needs to be subdivided in the near future. It is, I presume that the plan of the Maverick Hobbs family is to live happily in situ for many years to come. I wish them the best with that. And so the city does, WAPC does have the bulletin in relation to the right-of-way widening. The city does have a long-term approach to addressing right-of-way widening. However, I accept the concerns that have been raised in terms of, implementing the right-of-way widening at a time now when that space could be utilised for many years, and without any significant without any built form from the development proposed, and without any sort of significant infrastructure in place that would preclude it being removed should the right-of-way widening be implemented. So I think that it is not unreasonable in this circumstance to essentially just require that right-of-way widening is implemented at a later date on subdivision of the block or amalgamation of the land. So I think that's a reasonable approach in this instance.
Councillor Hallett.
Nothing on the amendment. Do we want to pass that first, or?
Does anyone wish to have any comment? Yes, thank you, Councillor Toppelberg.
Thank you. I've got a couple of questions. I support the principle, but I don't support the amendment in itself. I don't see why subdivision should be the trigger. For me, we either require it now or we don't. If we're going to allow a brand new home to be built on the back, surely the built form's existence once it's there, whether they're green titled lots or... I understand that without that there is no trigger then for council to actually ever be able to widen it, but effectively if we're building a brand new home and if you look at what's proposed, I can't see it going anywhere in any of our lifetimes or beyond. So for me, I'd have an issue with the requiring the subdivision as a trigger. If we don't believe the right-of-way needs to be widened, that should be sufficient. So if the amendment fails, I will likely seek just to delete the condition. But I do have a question through you to the Director of Development Services. 93 Walcott Street, it says in the briefing notes, it said a 1.058 metre widening of the rear of the property was provided on approved plan, and 95 Walcott Street, which I understand has its side boundary to Alma Road, it says a 1 metre setback of development from the right-of-way proposed, no conditions imposed. If you look at it from street view and if you go and look on site, there appears to be a significant brick wall built adjacent to the right-of-way. Can I just get clarity as to whether the right-of-way widening was required of 95, if what's been built complies with that, what was required of them? Because I can't see that wall disappearing in a hurry either, given that it's either, I'm not sure if it's green title or been there as a group dwelling, but there's a residence which has a significant wall immediately adjacent to the right-of-way. So if we can just get clarity as to what, I'm specifically looking at the entrance to the right-of-way from Alma.
Yes, through you, Mayor Cole. We haven't done an audit of that property's approvals. My understanding is that in 1995, when they sought approval, they showed a widening, and so that was on the plans, and so part of the requirements of their development. There is now a wall that's been constructed in that space. Whether that wall has had a subsequent approval, we haven't been able. We didn't find any obvious record of that, but we haven't done an audit of the records of the city to determine whether there is some approval in place, and we haven't done haven't taken any compliance action to first of all determine whether there's an issue there or not, and then to impose removal of that wall if there is.
Okay, thank you. And just for clarity, if the amendment, because the amendment also deals with the truncation, which I think is slightly different to the widening, but if the amendment is successful as worded, does that mean that the truncation on that corner doesn't need to be provided?
Through you, Mayor Cole, the truncation will need to be provided if the conditions are imposed as shown on the yellow paper. Yes.
Can I just follow up on that question, Director? The wording of 7.2 states it seems to appear the 2 metre by 2 metre truncation setback between the southern and eastern right-of-way setback areas. And are you saying that it's not included in the amendment?
No, it is included.
It is included.
Sorry, if I wasn't clear on that, I apologise.
So just for clarity, condition 7.1 as proposed in the amendment talks about everything being required to be provided at the time these portions of land are ceded to the city, and then 7.2 would say that doesn't need to be done until it's subdivided. So what I'm asking is if these homes are built and the land isn't subdivided, effectively the truncation no longer needs to be provided. So why I ask is that my concern, I am accepting of the arguments about the rights of way, but I do think that the truncation is a separate matter to the rights of way being widened.
Yes, through you, Mayor Cole, there is already a truncation in place for the existing right-of-way boundaries. So there's no safety issue with the current widths as they exist. If the right-of-way is widened, however, then the truncation will need to just move slightly in so that the safety and the sightlines for the new boundaries are the same as the current ones.
Thank you. Yeah, so just for clarity on that basis, I personally won't support the amendment, but if the amendment does fail, I would seek to move to delete the conditions relating to the widening of the rights of way without a trigger for widening them based on subdivision.
Councillors, any further comments on the amendment? Okay, I'll put it. All those in favour of the amendment? All those against? Sorry, I'm using my casting vote. A rare thing. Okay, that means that that amendment is carried. We're back to the substantive. Are there any further comments? Okay, there being no further comments.
The seconder wished to indicate.
Sorry. Yes, you wish to speak, Councillor Hallett? No? Okay. You do? Yes?
Sure.
Go ahead.
I will seek to delete condition 6.2, which is the short section of the balcony, the screening.
Is there a seconder for the amendment? Seconded, Councillor Gondrzejewski.
Thank you. I think that the principles, if you look at the landscaping at maturity in particular, I think that the principles of overlooking and the reasons why we provide those protections, particularly, and again, we have no guarantees about the future occupancy of this dwelling or the one at the front, but I think the principles, if you look at the landscaping and the nature of its location, it would take an extraordinary desire to actually position yourself to be able to look through there, and I do think that given that it is effectively west facing, it would have an undue impact on the light access, or potentially on the access to light and enjoyment of the balcony, and I'm comfortable with the submission of the applicant that they have taken reasonable steps, and given the oblique nature of that overlooking, you would pretty much have to either put your head around, specifically around that corner, to be able to see into that space. So I'll seek to remove it.
Councillor Gondrzejewski, do you wish to speak to it? Councillors, any further comments on the amendment? Okay, I'll put it. All those in favour? Declare it carried unanimously. We're back to the substantive again. Are there any further comments on the substantive? Okay, I'll put it. All those in favour? Declare the item carried. That takes us to item 9.6, which is number 441 William Street and number 6 Brisbane Place, Perth, hotel, restaurant and office development. Thank you. Can I have a mover, please? Move Councillor Gondrzejewski, seconded Councillor Toppelberg.
I'm supportive of the recommendation. I think we've gone through this one. I will wait and happily support an amendment in coming forward. But yeah, I don't really have anything else to say. I'm satisfied with this one.
Councillor Toppelberg.
Thank you. Further to the Mayor's question from last week, one of the things I quite like about the current plan is that you can, either whilst you're waiting or otherwise, you can actually, the activation potentially for that hotel reception area, rather than being a blank area where, especially in a 30-room hotel, where some poor soul is sitting behind a desk patiently waiting for someone to maybe walk in, you'll actually have the potential to carry your coffee and your laptop and sit in the window and actually activate that space differently to just being a cafe. I think the opportunity for an eating house that services the hotel and or the broader community internal to the development, given the northern setback, is a good opportunity for something different in that part of the street. I also like the way that the new plans have the bike hire. Whilst we've lost a few bikes potentially, the fact that it directly addresses the secondary street, I think is a good outcome, and that'd be a really, from a tourism point of view, it's a really interesting space to release onto your bike and head off towards Brookman and Moir and our heritage precinct. So I think that's a good opportunity. I do have an amendment proposed, which is on the pink, which I'll read out because it was very late. So there are two elements. One is an additional advice note, and the advice note is that the city reserves the right to modify on-street parking in accordance with its local laws if this occurs and impacts the loading bay. An amended service management plan is to be submitted to and approved by the city. And a new condition 4.1 would be amended to say the applicant is to apply to the city to convert the 2 existing on-street public parking bays adjacent to the subject site on William Street to be a loading bay. This area will remain as public parking and may be used for loading and drop-off/pick-up purposes associated with the proposed development. So if I can get a seconder, I'll speak to that briefly.
Seconded by Councillor Gonchevsky.
Thanks. So just for clarity, the way the condition was currently worded, it effectively says because we're requiring the applicant to pay for it. The current wording of it, I would just had some concern that an operator may look at it and say, well, those bays are ours, which they are not. They remain public, and the access, the service management plan, whilst it will rely on those bays, it's not for exclusive use. If a loading bay ends up being heavily used, there is no rights for the hotel to say that they have any special rights over times or otherwise of those bays. They would be publicly accessible, and I thought that the advice note was relevant, especially as William Street is to go two-way, that whether we look to widen the road and remove parking or widen the footpaths and remove parking, that's something that remains open to us. And whilst the two are related in terms of the current service management plan, that the creation of those bays is not for the exclusive use of the proposed development.
Councillor Gonchevsky, do you wish to speak to it? Are there any comments on the amendment? Councillor Murphy.
I just have a question. I'm just wondering what a loading/drop-off pickup bay would look like. Is that a specific loading, as in standard loading bay?
So the word drop-off pickup has been removed, but loading bay would be loading zone, which would be 15 minutes commercial vehicles only, is my understanding. Is that by definition? So it would be a loading zone. Maybe loading zone would be a better term, but yeah.
Thank you, Councillor Topberg. Would you like some advice, Councillor Murphy, on the difference between the two and whether administration has any preference? Director of Infrastructure and Environment.
Through you, Mayor Cole. So the loading bay is purely for loading, and so anybody like a ranger enforcing would have to ensure that anyone in the bay was actually unloading. Doesn't necessarily have to be a commercial vehicle. It could be suitcases out of a domestic car. So, but the purpose of the bay is short-term unloading and unloading.
Great, thanks. So it would be suitable for hotel patrons to. Yeah, great. So it's not really public parking then, is it?
No, anyone can use it, but it's not for parking purposes. So you could, there would be a determination by the person enforcing. If somebody was there too long and they weren't unloading, then that would be breaching.
I'd like to follow up on that question because I think it's a good one. Can I just ask? So prior to the amendment, the idea is that one bay will be a loading bay and one will be a drop-off pickup bay, which I assume is for visitors to the hotel to be able to drop down and get their suitcases out, etc. If it's changed to both car bays become a loading. No, there still is the proposal that it remains. Is it that one bay is a loading bay and one is a pick up and set down bay? Just seeking clarification.
Yes, through you, Mayor Cole. The
Sorry,
intent.
I'm asking the wrong director.
It's okay. In relation to the amendment, sorry, we prepared that in Development Services. The intent for the bay hasn't changed, so it's still intended to be used for loading, drop-off and pick-up. So it's not. So
it's not just commercial vehicles. It can be used for people visiting with an Uber. They can get out.
Correct.
And use it to enter the hotel.
Yep, or to drop off and pick up or load for other businesses in the area as well. It's not specifically for the hotel.
Okay, thank you for the clarification. Councillor Toppelberg, you have a question?
The original condition and the amendment refer to the two bays adjacent to the proposed development. There's only one bay, well, there's sort of two bays, but there's also a tree directly there, which means that they can't be continuous. And I don't know whether, certainly if the intent is for rubbish collection to occur and for larger trucks, they wouldn't be able to get in between the driveway of the property to the north and the tree. So just in terms of, and I understand from the site meeting a couple of weeks ago that the intent would be between the two trees to the south would be most likely, which is actually adjacent to the neighbouring development. Can we just get some clarity as to, if the condition is imposed, whether it would restrict the ability of rubbish to be collected by a large truck on site because the two bays adjacent to the property won't actually allow the manoeuvring of a truck to get in there?
Through you, Michael. I'm looking at the satellite picture now, so I know what Councillor Tolberg's talking about the two trees and the gap. I think if the intent is for there to be space there for drop-off, unloading, hotel patrons, commercial deliveries, if it's left as that intent, we will make that work and make sure that the measurement and the bay goes in the correct position, if Council is happy with that.
Any further comments on the amendment? Okay, I'll put the amendment. All those in favour? I declare the amendment carried. We're back to the substantive. Are there any further comments on the hotel application? No. Look, I just want to say I think it's great to have a new hotel potentially being built in the city of Vincent. Great addition to William Street, presents opportunities for more employment in the city, and I think some of the elements of this hotel in particular, with its laneway and with the emphasis on bike hire, are really positive. So really look forward to seeing this hotel come to fruition, and thanks to the applicant for your flexibility and for working with the city closely on that. I'll put the item. All those in favour? I declare it carried. Okay, we've some happy faces. It's nice to see. Sense of relief. Thank you. Good luck. We have now finished dealing with the items that were raised by members in the public gallery this evening, so we will now move through the remainder of the items sequentially. So the next item is 9.5, number 12 to 16 Cleaver Street, West Perth, proposed amendment to development approval, change of use from showroom warehouse to place of worship. Move Councillor Toppelberg, seconded Councillor Hallett.
Thank you. Support the officer recommendation. I just would like to propose the amendment on Orange, which imposes a 10-year validity to the approval.
I'll go to the seconder first. Do you support the... are you happy to second the amendment? Thank you.
Yeah, it's with an area in transition, whilst the impact on the current uses is less than what it may otherwise be. I just think that an approval of something of this nature without an opportunity to go back at some point would be potentially restrictive in the area, and 10 years I think is more than ample time. If there's been no change in 10 years, it wouldn't surprise me if there was another 10 years at that time, but yeah, I think it's appropriate to at least have an opportunity to look at development in the area at some point in the future.
Councillor Hallett, do you wish to speak to the amendment? Any comments on the amendment, Councillor Fotakis? No? No comments? Okay, all right. Yes, Councillor Murphy.
I did just want to see if there was, if the applicant was aware of this and if they had any opposition to having a 10-year restriction on their approval.
Through you, Mayor Cole, I'm not aware, I don't think the applicant's aware of this. The previous approval was able to be acted upon, which had I can't remember what the time frame was, 5 years I think, which gave enough confidence for them to set up the place of worship. It's already set up. This is a new operation. I'm confident that 10 years will be ample time to give them confidence to carry out the development and then come back if they would like to extend it.
Any further comments on the amendment? Okay, I'll put the amendment. All those in favour? Declare it carried. We're back to the substantive. Is there any comment on the substantive? Councillor Fotakis.
Thank you, Mayor. Through you to the Director of Development Services, I just want to ask us on the conditions 3.1 and 4 on the original application that hadn't been met, is there a time frame by which the current applicant is required to actually meet those conditions?
Yes, through you, Mayor Cole, the compliance team have advised that they will need to meet those requirements before they start operating as the new operation. So yeah, they'll need to do those works, and they've advised us that they're comfortable to meet that requirement. They're already looking at options to address those conditions.
Councillors, any further comments? Okay, I'll put the motion. All those in favour? I declare it carried. Brings us to item 9.7, character retention and amendment number 5 to local planning scheme number 2. We do have a couple of proximity interests, so just a few less of us to deal with this one. Can I please have a mover and seconder for this item? Moved Councillor Gontaszewski, seconded Councillor Loden.
I'm supportive of the officer recommendation. I know that there's an amendment on the hot pink, but I'll just say I'm happy that this body of work has been undertaken, and with the approach that has been decided upon. Probably my only thing is I wish we could probably had additional resources to be able to progress these sorts of bodies of work quicker. But that said, we can absolutely look at that in the future as part of our discussions. I'll actually put the amendment, and then we can ask some questions about that. The amendment is in relation to...
Councillor Loden, are you happy to support the amendment, or would you wish to speak as the seconder first? Okay, thank you.
Thank you. Just the amendment requires a significant portion of the building would be required to remove the two-dwelling... not to remove the two-dwelling restriction. And I guess I just wanted to get some advice in relation to how that might be interpreted on the ground. If there's any, I guess, current way that precedent, I guess, yeah. Percentage, yeah, doubtful. But yes, maybe there is. Yes, so I guess if I could just get some clarification on that, that would be great.
Through you, Mayor Cole, yes, we did have this discussion and considered like whether it was majority, but we didn't say majority on purpose. So significant portion, as we have interpreted it, is basically where it maintains all of those character elements that you can see from the street. So in most cases, that would be a significant portion, and that itself would satisfy it. So really, it's that second part of the sentence that's doing the majority of the work in that clause, and the significant portion would just be a second layer of protection, I suppose, for if somebody was proposing to just keep a facade, say, we would require a more significant part of it.
So, for example, if you had if the front 2 rooms and entrance hallway, veranda, etc., and all of those elements were retained, but the back 2 rooms, skilly and etc., so it's not literally, it's got to be more than half the building, it's more just that it has to make a significant contribution to the character. Okay.
Councillor Loden.
I don't have anything to add on that amendment.
Councillors. Look, I did sit on the fence about whether I would or wouldn't put this forward, but I do think that this change to the scheme is not insignificant, because basically at the moment you're only permitted to build 2 dwellings in this area. It is something that we had to fight pretty hard for when we went to Minister Wyatt to have our scheme finally endorsed. It wasn't something that was easily ticked off. There was certainly, I think, advice from the department not to proceed with this, so it was a sort of relatively hard-fought feature of our local planning scheme. So in order to move beyond that, we are really offering landowners in the area to develop their land more intensely. R40 means that you can build multi-dwellings. There would be differences in terms of setbacks to boundaries, etc. So it is an intensification. So my feeling was that if we were going to go down that path, then then some significant retention of a character home would really be necessary, because if it got to the point where it was a facade and you're opening up a whole lot of extra room to put apartments on your lot, that's quite significantly different to what has been endorsed in our local planning scheme. So I guess I've just convinced myself that I'm strongly in favour of this amendment. Are there any further comments? Okay, I'll put the amendment. All those in favour? Thank you. I declare it carried. Back to the substantive. Are there any further comments? I just wanted to request that in terms of the demonstration project in Mount Hawthorn, it does go beyond those that have initiated, and that we are going to seek to invite others to participate, and I think that's a great thing to do. Just a request is whether I could please be involved in the communications around how that invitation is made and what role council can play in helping that conversation happen. And just in relation to the process for the scheme amendment, it will be advertised, and then once we've received feedback from the community, what's the next steps from there?
Through Mayor Cole, similar to a policy, it will come back to the council for support, and if the council determines that no modifications are required, or if there are modifications and they support it, then we can send it to the state government for final approval. Before it goes out for advertising, though, it does need to go to the Environmental Protection Authority for their approval.
Thank you. So if this caused outcry, the community would be aware, and then we could deal with whether we actually think this is something the community would embrace or maybe not. Okay. So it will come back to us for final endorsement. Okay. All right. Are there any further comments or questions? Okay, I'll put the motion. All those in favour? Declare it carried. That we can invite our two councillors back into the room and say thank you to our Director of Development Services. Relatively straightforward tonight. Pretty calm in the room. Welcome back, councillors. We're now moving on to item 10.2, which is tender number 565 of 19, supply and delivery of 2 waste collection vehicles, appointment of successful tenderer. Mover, Councillor Loden. Seconder, Councillor Hallett.
Thank you, Mayor, and apologies to my fellow councillors. If I was here last week, I would have asked my question there. Obviously, the Director of Infrastructure and Environment was very disappointed I wasn't here last week as well. My concern with this was around, partly around process, for the evaluation process. We're evaluating on a capital item here, but they do have an operational cost over the 5-year life of these assets. And because you are consuming fuel in that process, that is not insignificant. I sent through a few questions to the Director on Monday, and he was able to answer most of them, but there was one question outstanding, which was just around if he was able to come up with an estimate of what the cost is to the city for running those vehicles over the next 5 years.
Through you, Mayor Cole, not this evening. There is some work going on about the cost of the current vehicles, so we can do a comparison. I think in my conversation with Councillor Loden this afternoon, I did explain there's a number of variables. So the manufacturer that provides a truck then fits a back onto the truck, and there are a number of variables that make it difficult to get an accurate cost over 5 years. But we certainly can do a, an educated estimate on what the cost may be, and part of that is based on the current cost of the current vehicle too, so we know the kind of kilometres it's doing, etc. So.
Thank you. I did my own educated guess, which adds up to about $130,000 over a 5-year period for a standard truck. So that's driving 5 days a week, average of 25 k's an hour for roughly 5 hours a day, and then multiplying that out. You find that rubbish trucks are very inefficient because they're idling a lot of the time and stopping and starting, so they're probably the most polluting vehicles out there on the streets. $130,000 is not insignificant compared to the capital cost of these things. So a vehicle that was slightly more efficient would potentially make a difference. I am comfortable that the evaluation has landed on the right answer, but I would like to see us include those considerations in the future, because if those numbers are tighter and it was not as clear a decision, you could see that this would change the outcome of our decision. Obviously things like maintenance costs and so forth come into that as well. We should have an idea of that information and should be able to make a reasonable estimate of that, and it's a good thing for us to consider in the future. I do have an amendment as well, which I'll talk to, but I'll let others speak first if they wish, and then move my amendment.
Before Councillor Loden moves his amendment, do any councillors wish to speak to the substantive? The floor is yours, Councillor Loden.
I'm shocked. So my amendment is to request administration to seek quotes from providers of electric-powered waste trucks and compare these quotes, including life cycle costs, against current purchased vehicles, to determine if an electric vehicle is viable for the city, and provide this report back to Council prior to the next purchase in the waste fleet. This analysis should consider the carbon emissions reduction and amenity noise benefits as well, if I could get a...
Is there a seconder for this amendment? Councillor Gonczewski.
Thank you. I guess my point here is, as I referred to earlier, my estimate, $130,000, we'll see what the actual cost is once administration has had a chance to look at it. It's not insignificant. We know what the price is from our tender in the confidential section, so I won't refer to the dollar values there. But an electric vehicle, if that was less than $130,000, would be a better outcome for the city from a cost point of view. You also have the added benefit with electric vehicles of no noise. Before I had small children, I occasionally used to get woken up by the rubbish truck driving past. An electric one would not do that. I've probably got another 10 years before I can look forward to that happening again. But anyway, and you've also got the carbon emissions and associated NOx and SOx that are produced through diesel combustion as well, that would be avoided through an electric vehicle. It also fits very, very firmly within our sustainable environment strategy, which we are hoping to adopt very soon. So I would ask for your support for this amendment.
Councillor Gonczewski.
I have a recollection that electric vehicles were mentioned by the Director last week, in that it wasn't assessed to be a provider. Could I just request a clarification on that? Because we did talk about it last week.
Okay. Through you, Michael. Yeah, there was a question last week, and my answer was along the lines, as follows. When we did a tender last year, we specifically asked for a diesel vehicle of Euro 5 or 6 or better standard. So we did specifically. We didn't actually, the tender didn't allow for an electric vehicle. Electric vehicle couldn't have met the specification. So bearing in mind this is an emerging market and electric vehicles are just starting to creep into Australia, and there'll be one in WA in June, which sewers are going to use in the city of Belmont. On this occasion we opened the tender and we allowed non-diesel vehicles, so we were agnostic about the technology that drove the vehicle, so we did open the door. So it's definitely an emerging market. We're definitely very interested. We're already speaking to the manufacturers about the options and the availability and the specifications, etc. So there will come a point in the future where we'll be able to be a bit more robust about that in a tender. So in terms of the amendment, we're fully supportive. That is absolutely the work we're doing anyway, so we're supportive of following that route, and we hope that in the not too distant future there will be a viable alternative to diesel available for us.
And the term quotes is obviously indicating that this is not a formal process. This is just to essentially test what's available in the market and to get to some idea around running costs and some of the items that have been mentioned. It's not going to be a significantly
Yeah, that's correct. Through you, Michael, that's correct. We would like to put an indicative cost in next year's budget. There's 2 waste vehicles due for replacement next year. So we'd like to put an indicative cost, which is what we do anyway. We put an indicative cost for a diesel vehicle, and then we go to tender, and it usually fits the budget. So, but we honestly can't tell you what an electric vehicle would cost, but we're very close to knowing, because some of the manufacturer will give me an indicative quote in the next few days, hopefully.
Okay, thank you. I'm supportive of this. I just wanted to get clarification around the resources associated with getting quotes prior to actually then potentially undertaking formal tender processes, etc. But yeah, absolutely agree that ongoing fuel costs and noise as well absolutely should be part of our decision making when purchasing these vehicles, and it's great to see that there may be some coming online.
I'm just going to ask a follow-up question to Councillor Gontaszewski's question. Just in relation to the language seek quotes, completely support the principle. I just like in the local government setting, when you're seeking a quotation, that indicates some kind of procurement process to me, and I'm just wondering whether it might be better to say something like seek pricing or costings, or something that doesn't perhaps suggest a starting of a procurement process where we then might have to say, well, we now have to seek this many quotes because we're seeking quotes from this organisation. So just a question on that process and whether that wording is problematic.
Through you, Mayor Cole, if council are happy, I would insert the term indicative cost, which is the wording I used when I spoke to the manufacturer.
I'm happy for that change to be made.
Thank you, Councillor Loden. Second, are you happy for the wording seek quotes to change to indicative costs? And then it would also follow on to say, and compare these costs, including life cycle costs, against current purchase vehicles. Yep. Thank you. Okay, Councillor Toppelberg.
I'll speak to the Director after, but just to clarify also that life cycle costs will include the cost of battery replacement and likely resale value, because if the batteries, for example, if we have a 5-year program and batteries have a 7-year life, and they are, from my understanding, wildly expensive to replace, that may have a significant impact on resale value, or indeed if the battery needs to be replaced during the life, obviously that contributes, but just that we are cognisant of the end of life value to the city as well.
Through you, Mayor Cole, that's absolutely what we'll do, the entire cost, including battery replacement, if that's required, within the period that we keep the vehicle, and we do always look at the resale cost at the end of the time with the city.
Councillors, any further comments on the amendment? Okay, I'll put the amendment. All those in favour? I declare it carried. Back to the substantive. Any further comments? Okay, I'll put it. All those in favour of the motion? Declare it carried. That takes us to item 12.1, Draft City of Vincent Innovate Reconciliation Action Plan 2019 to 2021. Moved Councillor Loden, seconded Councillor Fotakis. Was that your... Yes, thank you.
Thank you, Madam Mayor. This document is basically the same as what we saw, I think, last month from memory. So there was a few comments that came through there that will make some minor changes, but it's probably the same document, which is great to see. I think our RAP is a fantastic document. We actually had our RAP working group meeting yesterday with the group, and we had a quite robust discussion there on the day. One of the interesting reflections that I thought I would share is that one of the members commented that it's easy enough to draft these documents and get them through and tick the boxes and progress through the levels and so forth. It's really about how you give life to those actions that will actually determine what happens within your organisation. It's which is, at a council level, we have a document that says this is what we're going to do, but it's really down to the administration, to the staff on the ground that are doing the day-to-day work that's actually going to determine how well this becomes a living document. I think I referred to this last time. One of the big challenges we have is around that procurement space, and a big challenge in the corporate services space and the infrastructure space is how do we increase opportunities for Aboriginal businesses. And that will ultimately come down to those staff that are looking at those items and saying, how can we get an Aboriginal business to put in a tender for this item? If we are successful in getting one, what is the reason why this is not the person that we can select for that option? How do we actually drive this through our organisation? It's difficult to dictate something like that in a RAP document, but if this is a truly living document and something that the organisation embraces and the staff really engage with, then we can see this progress and achieve really tangible outcomes. The second thing I just wanted to refer to was the Acknowledgement of Aboriginal and Torres Strait Islander cultures and histories that's included in here as well, which talks about constitutional recognition and also support for the Uluru Statement from the Heart. These are, I guess, something that is not at local government level in particular, is more an advocacy place. This happens at a federal level, but it's really about showing support for the Aboriginal and Torres Strait Islander peoples of our nation. It is a really challenging space, obviously, but every meeting we start our meetings by acknowledging the traditional owners of the land, the Whadjuk people of the Noongar Nation. And one of the realities we have is that this land was never ceded to those people. They never ceded that land to us here. That is unfinished business, and we talk about reconciliation. That is something that is yet to be resolved. It's going to be an ongoing thing, but if the city is prepared to stand up and put our voice to the voices that have already supported this place, that will actually help in that change within the country, hopefully. So, thank you.
Thank you, Councillor Loden. Councillor Fotakis.
Yeah. Just be brief. I've said it before with regards to the work of the Reconciliation Action Group. Really quite an amazing group of people with the support of our staff to see the work that really comes out of the engagement, and I love that term, living document. I think it's probably one of those that I think if you put your ear to the document you can hear a heartbeat. There's some real emotion that comes with the work that's done and some real dedication, and I think you can feel it in our city. You see it even at our citizenship ceremonies. You see it across all the work that we do, and I believe that we are making a difference. I believe the leadership that's been shown in the city for very many years is flowing on to other areas, and I'm proud to actually be part of that process. So well done to the RAP group, well done to the staff and everyone involved.
Councillors, look, just to add to Councillor Fotakis' comments, I'd like to say that I think there's been some really solid work that's been done in building really strong relationships and partnerships with Aboriginal organisations, Aboriginal people, Aboriginal elders. I think that our staff member, Gaia Sirendorf, who does this work, is exceptional in building those relationships and reaching out to people. She's been doing some fantastic work, supported by our council with an incredible RAP group. Council members, we have now the strongest Noongar representation, Aboriginal representation on that group. It's, I think it's a testament to the work that we're doing, that people are actually thinking that it's worth investing their time, worth getting involved, because we are actually really serious about this, very authentic in our desire to make change. And today Danny Ford rang me to say thank you for the article in the West Australian. He said it was unapologetic and that he absolutely appreciated that. We are very strong and authentic in our approach at the City of Vincent, and I think that really shines through and makes a big difference. So a huge thank you to all involved, and also to Mick as well. Thank you, Mick. Almost forgot, but didn't quite. Any further comments? Okay, I'll put the item. All those in favour? I'll declare it carried. That leaves us only with confidential items to deal with now, so we will take a break from the live stream and say thank you to those who've joined us on the stream, and I will need to seek a mover and seconder to go behind closed doors. Move, Councillor